Welcome to the next episode of Small Business Legal Tips. So you're building a new app and you're trying to find the perfect name. That's exciting. But the name is more than just a name. It's one of the most valuable assets you'll build in connection with your app. Picking the right one can help you build a valuable and recognizable brand that will be distinctive in the marketplace and readily identify your app from your competitor. Picking the wrong one can lead to a nightmare scenario. A cease and desist letter from an attorney demanding that you stop using the name, or a flat-out rejection from the United States Patent and Trademark Office, which is called the USPTO. Either scenario will cost you thousands, as you'll need to go back to square one and rebrand. I'm attorney Mark Bross of Bross Law LLC, and I'm a practicing small business attorney. For years, I've been helping app developers and entrepreneurs protect their brands by obtaining and registering trademarks with the USPTO. In this video, I'm going to walk you through the 5 legal considerations that you want to take into account to make sure that your app's name is strong and can be registered as a trademark with the USPTO. Trust me, you want to get this right from the beginning in order to save your future self some time, money, and headache down the road. And please, if you'd like to get more helpful legal tips for your business, please hit the like and subscribe button below. So let's get to it. First consideration, the spectrum of distinctiveness. Okay, the very first thing you want to understand and consider is what lawyers call the spectrum of distinctiveness. This is a spectrum that determines how likely your name is to be registered with the United States Patent and Trademark Office, the USPTO, and how strong of a trademark it will be. At the low end of the spectrum, you have almost no likelihood of getting it registered with the USPTO, and even if you do, it won't really serve to distinguish your app from any competitors. At the top of the spectrum, you have a strong likelihood of getting it registered, and it will really serve to identify your app in the marketplace. So you really want to choose a name that's at the top end of the spectrum. At the very top of the spectrum are, quote, fanciful marks. These are words that have no inherent meaning, but are completely made up or coined to be used in connection with your goods or services. Think of marks like Google or Rolex. These words had no meaning before they were created by the companies and were especially created to be trademarks. This makes them easy to register with the USPTO, and they provide the strongest level of protection because they are very distinctive and are readily distinguishable in the marketplace. For an app, you might invent a name like Zorbo for a photo editor or some other random name. Since the word is brand new, it's highly distinctive, would be easy to register with the USPTO, and would readily distinguish your app from others in the marketplace. The next level on the spectrum are what are called arbitrary marks. These are real words with meanings, but the meanings have zero connection to the service or product it is being used with. The classic example of an arbitrary mark is Apple for computers, cell phones, and other electronic products. An apple is a fruit that has nothing to do with computers or other electronic products. And this separation is what makes the mark so strong and easy to register with the USPTO. For an app, this could be a name like Forest for a podcasting app. A forest is a collection of trees and has nothing to do with what the app does. This would make it a good candidate to be registered with the USPTO and would provide strong protection because it easily distinguishes your app from other apps in the marketplace. Moving down the spectrum, we get to suggestive marks, which are names that suggest or hint a quality or feature of the product or service, but do not directly describe it. They require a little leap of imagination to make the connection. Think of the name Greyhound for the bus service. It suggests speed. Or Netflix for movie rental and streaming services, which hints at movies on the internet. Both are great examples of suggestive marks. Suggestive marks can be registered with the USPTO because they are distinctive and can be strong marks, but sometimes the registration process can be a little more difficult and may require argument with the examiner to show that the mark is not descriptive. For an app, this could be a name like ClearPath for an education or teaching app to suggest that the app helps kids navigate through school. The next level down in the spectrum are descriptive marks, which are marks that use words that describe a characteristic or feature of the underlying product or service. Think of trying to use the name Fast Chat in connection with a messaging app. These words literally describe what the app does, and they create a weak mark because they describe what every messaging app in the world does and would not really serve to distinguish your app from others in the marketplace. Descriptive marks generally can't be registered on the principal trademark register with the USPTO until they acquire a secondary meaning, which can take up to 5 years of using the mark in commerce and spending a lot of money in advertising to the point where people who hear Fast Chat in connection with the messaging apps will think only of your app. It's a very high bar to clear and will require argument and evidence with the USPTO in order to register your mark. And at the absolute bottom of the distinctiveness spectrum are generic terms. These terms are just the common names for the product or services that you are using the mark with, and you can never trademark generic terms. In connection with your app, for example, you can't trademark the name app. If you try to apply for a trademark for your app with the word app in it, the trademark will be rejected, or you'll have to disclaim the use of the word app apart from your trademark. So in light of the distinctiveness spectrum, when choosing a name for your app, you want to pick a name that's fanciful, arbitrary, or at least suggestive. Stay away from descriptive and generic names if you want a brand name that you can register as a trademark and will serve to distinguish your app in the marketplace and identify your app. The second consideration, likelihood of confusion in the trademark search. After you've identified a name that is distinctive and memorable, the next consideration is to make sure no one else is already using a similar name for a similar product. The legal test the USPTO uses is called likelihood of confusion. If your app name is too close to an existing registered trademark for a related good or service, your application will likely be rejected by the examiner because it is confusingly similar to the existing mark and would likely cause confusion, mistake, or deception. The whole point of a trademark is to identify the source where goods or services are coming from and to keep customers from getting confused about who is producing the goods or the services. So what does confusingly similar really mean? As with most legal concepts, it's a little bit complicated. When assessing likelihood of confusion, the USPTO uses the DuPont factors, which come from a 1961 landmark case. This is a multi-factor test, and the USPTO is supposed to consider all relevant factors, but there are usually two key factors that influence the USPTO's decision. The first key factor is the similarity of the marks. The USPTO will compare the overall commercial impression created by the marks in terms of looks, sounds, meanings, and connotations. Marks do not have to be identical in all features to be considered identical, and the more features that overlap, the more likely the two marks will be found to be confusingly similar. The second key factor that the USPTO will look at is the similarity of the goods and services for your proposed trademark and the registered trademark, and the degree to which they overlap or are related. If the two marks are for similar goods and services, the USPTO will examine the marks very carefully for potential similarity because marks for identical goods and services are more likely to be confused. No DuPont factor is meant to be dispositive, but if your proposed mark is similar to the registered mark and is for similar goods or services, your proposed mark will likely be found to be confusingly similar to a registered mark and will be likely rejected by the USPTO on the grounds that it is reasonably likely to cause confusion. Suppose, for example, that you want to call your new fitness app FitLife, spelled F-I-T-L-I-F-E, that helps users achieve their fitness goals, but there's already a registered trademark for FitLife, spelled F-Y-T-L-Y-F-E, that sells workout supplements. Based on the two DuPont factors discussed earlier, you're probably going to have a problem registering your mark with the USPTO, and it will likely be rejected on the grounds of likelihood of confusion. Even with different spellings, they sound the same and have the same meanings, and fitness apps and workout supplements are closely related. It may not be impossible, and the other DuPont factors could come into play, but it will likely require extensive argument with the USPTO and could cost you a lot of money in legal fees. This is why you should consider running a thorough trademark search before you get attached to a name or filing for a registered trademark with the USPTO. Simply Googling it and calling it a day is not enough. You need to start with the USPTO's own search database, which is called TESS, the Trademark Electronic Search System. This lets you search all federally registered and pending trademarks. I'll put a link to the website below. But a quick do-it-yourself search is not enough to clear the potential name for your app. The TESS database is complex, and it's easy to miss things like phonetic equivalents or different spellings. Plus, in the US, a business can also register a trademark in the state where they are operating and using the mark, and they can also have a common law right to a name just by using it in their local area, even if they don't have a federal or state registration. This is why it's often a smart move to have an attorney with trademark experience or a professional trademark search firm run a full trademark clearance search. They dig much deeper and look at federal and state records, business names, and domain registries to give you the full picture. Paying for a comprehensive trademark search up front is a lot cheaper than a lawsuit or rebranding your entire app later. Third consideration, use in commerce or intent to use application. Once you've found a name for your app that is sufficiently distinctive and you're sure that it is not similar to any other registered trademark, the next consideration is what type of trademark application to file with the USPTO. And there are two options, depending on where you are in your app development. an intent to use application, or a use in commerce application. The first option is if you are in the very early stages of your app development and the app is not yet finished or commercially available. If your app is in this stage, you should file an intent to use trademark application, which is also called an ITU application. As part of the ITU application, you'll need to certify that you have a bona fide intent to use the proposed mark in commerce in the future. There are multiple benefits to an ITU application. The most important benefit is that it will set the date of your first use of the mark in commerce, assuming that your application is approved, and you go on to actually use the mark in commerce and take all other necessary steps to register the trademark. The most important future step will be to file a statement of use, which is called an SOU, and provide a specimen that shows the use of your app in commerce, such as by showing a screenshot that shows your app is available for download from an app store. We'll talk about specimens more in a minute. The SOU will need to be filed within 6 months of the date the application is approved by the USPTO, although you can request 6-month extensions for up to 3 years. No matter what date you file your SOU, the date of first use in commerce for your mark will be retroactive back to the date you filed your ITU application. So for example, if you file your ITU application on August 1st, 2025, but don't file a statement of use until January 1st, 2027, your date of first use in commerce will be retroactive to August 1st, 2025, which can be very helpful in the event of a trademark infringement dispute over your use of the name for the app. Generally speaking, under U.S. trademark law, the first person to use the mark in commerce has priority and rights to use the mark over other users. The second option for a trademark application is a use in commerce application, which you want to use if your app is already commercially available and being downloaded and used by multiple people across the U.S. As part of this application, you'll need to provide evidence, which is called a specimen, to the USPTO that proves how you're actually using the mark in commerce in connection with the goods and services that you have applied for in connection with your trademark application. You'll also need to provide the date that you first started using the name in commerce and also the date that you first started using the name anywhere. One question you might have is, what type of specimen should I provide to the USPTO to prove that the name is being used in commerce? That's a great question. For apps, the best specimen is a screen capture from an App Store listing, such as the Apple App Store, Google Play, or any other app store, that clearly shows the mark being offered for download. Make sure that the screenshot shows the App Store where it came from, the actual mark you're applying for, the number of reviews that the app has received, and a description of the app that matches the description of the app in your trademark application. Along with the screenshot, you'll also need to provide the USPTO with a description of where the screenshot came from, the date it was taken, and an explanation of how the screenshot shows the use of your mark in commerce. It does not need to be lengthy, it just needs to be an accurate description of what the screenshot shows about your mark's use in commerce. If your app's not available in an app store, then you'll need to provide a picture that shows wherever your app can be purchased or downloaded. For example, if it's only available for download from your website, you'll need to provide a screenshot from the page where the app can be downloaded. The screenshot should show the mark that you're applying for prominently displayed with a clear download button and a link to pay for the app, if applicable. Along with the screenshot, you'll need to provide a description that includes information about the website where the screenshot came from, the date the screenshot was taken, and a description of how the screenshot shows the use of your mark in commerce in connection with the classes that you are applying for in the trademark application. One important thing to note is that in order to successfully register a trademark for your app must actually be downloaded and used by real customers. Simply offering the app for download is not enough to register a trademark under a use in commerce application. The app must actually be downloaded and used by real customers. This doesn't mean that you need to sell your app for money, since there are plenty of apps that are offered for free. But the app must be downloaded by actual customers and not just your friends and family. So how many customers is enough to actually be considered used in commerce? There's no magic number, but if you have over 75 downloads, and some of them are located from different states in the US, you've probably met this requirement. If you're finding this information helpful, please do me a quick favor and hit the like button. It really helps the channel and tells me I should make more videos like this to help you protect your business. The fourth consideration: proper identification and classification of goods or services. After you have figured out the type of trademark application that you're going to be filing, the next important consideration is a bit technical, but it's where people often get confused. A registered trademark doesn't stop people from using your name in connection with every business under the sun. Instead, it only stops potential competitors from using the name in connection with the goods and services that you identify in your trademark application. The USPTO uses a system with 45 different potential classes of goods and services for your trademark application. And this includes classes such as chemicals, paints, clothing, telecommunications, education and entertainment, and many others. I'll provide a link below to the USPTO classification system. For an app, you have to pick the right class for what the app does and write a very specific description describing what it does. Many downloadable mobile apps fall into Class 9, which is for electrical and scientific apparatus, but they can also fall into other classes depending on what the app does. For example, if you have a health mobile app and it provides information about physical exercise via social media, you would need to file in Class 41. Or if you have a mobile app that provides retail store services, you might need to file in Class 35. Filing with the wrong classification can provide you with limited or no trademark protection or get your application denied by the USPTO. In order to identify the right class for your trademark application and a possible description, you should use the Trademark ID manual, which is provided online by the USPTO. I'll provide the link to the website below. This is a searchable database of approved descriptions with the appropriate classifications. You just plug in a term such as mobile applications or software, and it will generate possible descriptions. You should run multiple searches to capture all possible variants and then use the classification and the description that best fits your app in your trademark application. Now, one thing to note is that starting in 2025, the USPTO has changed its fee structure. The cost for filing any trademark application is at least $350 per class of goods or services. So for example, if you file a trademark application for your app in Class 9 and Class 41, that means that the filing fees for your trademark application will be at least $700. However, it could be more than $700 if you don't use one of the descriptions contained in the ID manual or for various other reasons. So when you're searching through the ID manual, one of your goals is to be on the lookout for a description that you can use in your trademark application. If there's not a suitable one, you can still create your own description, but it will just cost you a lot more money. When choosing a classification and description for your trademark application, the key thing to remember is that you can never add classifications or expand your description after you file the trademark application. You can only delete classifications or make your description more narrow. So before filing, you have to think through everything your app does and might do in the near future. Is it a game? Does it have social networking? Does it sell virtual items? Each function or potential function that it will be doing in the near future should be in your trademark description to make sure your registration fully protects you and your business. This is obviously a balancing act between the cost of the trademark application and the desire to obtain as much protection as possible. But you need to balance these considerations carefully to try and obtain as much protection as you can afford. The fifth consideration, ensuring your mark and app are lawful. One final point to consider with respect to any potential trademark application is that in order to obtain a registered trademark, your app must not do anything that violates U.S. federal law. The USPTO will refuse to register a name for any good or service that is illegal under federal law. The most common example right now is with respect to the cannabis industry. Even though many states have legalized cannabis, marijuana is still classified as a Schedule I substance under the Controlled Substances Act and is still illegal to sell on a federal level. So if your app is designed to sell marijuana for your retail marijuana dispensary, the USPTO will refuse to register the name of your app as a trademark, and it doesn't matter that the business is perfectly legal in your state. Beyond that, your application itself has to be filled out completely honestly and accurately with the right applicant name, a clear drawing of your mark, and all other required information. Applications are signed under the pains and penalty of perjury, and the USPTO is now charging additional fees for applications that are incomplete and missing information that should have been included from the get-go. And if you're filing from outside the US, you are now required to hire a US licensed attorney in order to represent you and file your trademark application. Okay, that was a lot. So let's recap the 5 key considerations to focus on when choosing a name for your app so that it can be registered with the USPTO. The first consideration is to choose a name that's fanciful, arbitrary, or suggestive so that it's distinctive and can distinguish your app in the marketplace. Avoid descriptive or generic terms at all costs. The second consideration is to run a deep search on the name to make sure that the name isn't already taken or confusingly similar to another registered trademark. The third consideration is to know whether you're filing an application based on use in commerce or an intent to use the mark in commerce in the future. If it's use in commerce now, make sure to assemble all the evidence you need to prove actual use in commerce. The fourth consideration is to correctly identify the right classes and describe exactly what your app does to get the right protections with your trademark application. The fifth consideration is to make sure your app's functions are legal under federal law and that your trademark application is filled out completely and accurately. Thank you so much for watching. If you have any questions or suggestions for future topics, please drop them in the comments below. And don't forget to subscribe and ring the bell to receive more essential legal tips for your business. See you next time.